One of the cases that's been receiving a lot of headlines recently is Vanessa Bryant versus County of Los Angeles. The allegations are that Los Angeles County Sheriff's deputies who responded to the crash scene took photographs of Kobe Bryant's body and other victims and shared them. The case has been vigorously litigated by both the county and Vanessa Bryant's attorneys. Among other things that happened, Alex Villanueva, the sheriff of Los Angeles County, ordered that all of the photographs that any responders have be permanently deleted. That resulted in an evidentiary sanction by the Central District Court, Judge Walter, because there's a duty in federal court, and for that matter, state court, to preserve evidence once a case begins. And the excuse that it was for the protection of the victims certainly wasn't accepted by the district court. You may ask yourself, why is taking photographs of something in a public field, why would that give liability on behalf of the people taking photographs? I mean, if you think about it, you're driving down the freeway, you see a fiery crash, you take a photograph. What is it that forms the basis of liability? In this particular case, you're talking about Los Angeles sheriff's deputies, and there's a case called Katsouris versus Department of California Highway Patrol, which is a 2010 case. And in that case, the officers involved in a horrific crime scene took photographs of a decapitated corpse, and then they sent them to friends and family on Halloween for shock value. And in turn, people receiving it disseminated on the internet and otherwise. And the court in that case held it was perfectly foreseeable that the public dissemination via the internet of photographs of the decapitated remains of a teenage girl would cause devastating trauma to the parents and siblings of that girl. Moreover, the alleged acts were morally deficient. We rely on the CHP to protect and serve the public. It's antithetical to that expectation for CHP officers to inflict harm. So you actually have to have foreseeability of harm. The plaintiff, degree of certainty the plaintiff will suffer damage, and a policy of preventing future harm. Now, in this case, one of the deputies involved showed pictures on his cell phone to a bartender, and the bartender was speaking to a customer and said, "Hey, I've seen one of my regulars is a Los Angeles County Sheriff's deputy, and he showed me some horrific scenes from the Kobe Bryant crash." And in turn, that customer reported the incident to the county authorities, and they went and obtained the video that was going on as a security camera inside the bar, and indeed found that one of the deputies had shown this to one other person. The county argues that the plaintiffs themselves didn't see it, so it couldn't cause massive emotional distress, nor was it widely disseminated, nor are there other instances in which it happened that it's really too much, too little to stretch that to say that fits into the Katsouris case. Well, in any case, this was briefed, and the motions to dismiss were denied, at least with respect to the officers that took the pictures. And the summary judgments were denied, sending it to a jury, which is relatively rare in the Central District. It most certainly happens in well under 5% of the cases that are filed. But the county's defense and the plaintiff's arguments will be considered by the jury with a verdict to come out promptly. John Belcher, Vanessa Bryant versus County of Los Angeles, Law Offices of John Belcher.